So today I am discussing something that's come up a lot in the paranormal community on YouTube. And I don't know that I'm the best person to talk about it or not. I've been affected by it. Basically, what I'm going to talk about today is paranormal reaction channels or paranormal reaction videos. So I wrote an article a little while back and I published it on YouTube. And it's if you go to my community posts, you'll see it under there as original content creators have rights. It actually was originally posted to my Positive Writer blog, but recently, because of all these questions I've been getting in discussions with others on YouTube about creator rights, I decided to write an article on there. So I wrote an article on Positive Writer. What I've always done in my life is travel. I love traveling and I love everything paranormal. I'm a paranormal enthusiast, let's say it like that. And so I mix the things together and I use my paranormal travels channel to really use the paranormal in a way of getting these lesser known and sometimes really famous locations seen by those who normally would never discover these places. And on the paranormal travels, what I've noticed over the last couple years that I've been doing it, and a little bit more lately, is that there's these reaction channels. Now, in general, I don't really have a problem with reaction channels, but the paranormal reaction channels are very unique compared to reaction channels, non-paranormal. It's very, very important to understand your rights, because if you don't understand your rights, to be blunt, is that there's others out there who may take your content and use it in ways that you don't approve of, and they'll tell you what they're doing is legally sound and it's absolutely authorized, and you'll be like, oh, okay. I've had content misused in several different ways. I've had it re-uploaded to YouTube. I've had it uploaded to Amazon. I've had it uploaded to so many different places. People trying to sell it, not just my videos, but my books and other content. And that's something, if you don't understand your rights, you're going to have a really, really challenging time. And the unique thing is, I've discovered with writers and authors, they know a lot more about copyright. I'll give you a couple examples right off before we get into this article, is that I've seen people outside the United States claim fair use. Well, first of all, fair use is a U.S. defense in court. It's not a pre-approved authorization to use other people's content. It is a defense used in court. Now, of course, you can usually have an idea about whether your content is fair use or not. Like, for example, if you're showing minor clips and you're saying the angle of the camera could be this way, or I would have shot it this way, that's, some criticism. Now, saying, hey, that guy, that's a lie. That didn't happen. That is a accusation against the creator. That's different than criticism. That's discrediting, and it is also accusatory. So that's very different than criticism. Criticism of the work is different than accusations. But I don't want to get too far ahead of myself, but that's an example. Also, I've seen some paranormal reactors saying, oh, I have safe harbor. I'm telling you, folks, you need to learn your rights. Creators, if you don't know your rights, you're going to listen to these folks and believe they're telling you the truth, which is kind of ironic. You have people in the paranormal reactions trying to discredit paranormal creators, but at the same time, not exactly being honest with their own audience. Either that or they don't understand the rights, like, for example, safe harbor. Safe harbor is for the platforms which allows them to have content creators post on their platforms, and they have an immunity as long as they follow the rules and regulations of the law, in this case the DMCA. So if the platform states they have safe harbor, they do. But the individual creators do not. You do not have that immunity. I don't, you don't as a creator, but the platform does, because the platform at first is not responsible for what you create and what you put online. However, once they receive a takedown notice, they have to make a determination, and based on that interpretation, they decide whether they keep the content online or not. And that goes for all platforms, not just for YouTube. That's all platforms. They all have to follow the law. So yeah, online platforms have safe harbor provisions that protects them from being directly liable for copyright infringement by users. But this protection is conditional. As a user, again, that does not qualify for individual users. But I see reaction creators who are basically trying to call other people, not all the time, not all of them, so let me be clear about that, but some of them calling other people liars, while you don't have safe harbor if you're an individual creator. And if you're outside the United States, you really don't even have fair use. Now, okay, platforms will default to US law at first, but once jurisdiction is clarified, they usually will take that clarification, verify it for themselves, because platforms can do that. They know where you're uploading, and then decide. Now, I won't say what a platform will decide or won't decide, but who am I to decide that, right? But they will take jurisdiction into consideration. So, and I do agree that the fair use descriptions and for fair dealing and so on are kind of not really clear on these platforms. I've read some. It's best to go directly to them, because, like, for example, you can go to the United States Copyright Office and look up fair use, and you can also talk to intellectual property lawyers and go on from there. So I'm going to read you the article word for word. One thing I've learned in intellectual property, the more you know, the more protected you are, but also you have the ability to know what the other person's doing wrong. Let me go ahead and start reading it. So, original content creators have rights. I've been asked to share my thoughts on paranormal reaction videos. Yes, I've been asked. Several people have been attacked by these reaction creators, and we use the word attack because a lot of times it's not very nice, and I mean, it's not. So anyways, so I've discussed behind the scenes with a few of the creators, and I've had a few write me and said, hey, what did you do to get that content taken down? And it's been quite a few, actually. And what I've noticed is that a lot of reactors basically just want your content to improve their sites. They're going to take content that's going viral and use it for themselves so they can get themselves a viral video while they discuss it. Anyways, let's not get too far ahead of myself. This isn't about calling anyone out, and I am not going to name names. I'm not going to talk about any particular YouTube channels. It's not about debating skepticism, and I'm not going to take sides on paranormal claims. That's not what this is about. I'm not going to say, well, that person was right, that is paranormal or not. Let's stick to creator rights based on my general observations and decades of experience protecting my own intellectual property, also working with other authors and helping them publish their works. Okay, so I've gone through the disclaimer already. I posted it on this so you know that. The main issues I have with my many paranormal reaction creators is their use of others' work without permission. As an author, I've had my share of criticism, and that's fair. So, for example, Roger Ebert, he was a famous film critic, but he did not take other people's content or attack others. And I can pretty much gauge that most of the paranormal reaction creators out there will never be as famous as Roger. Okay? I won't. A lot of people won't. I've interviewed some pretty famous people in that realm, such as Seth Godin, Jeff Goins, and others. And no one reaches the level of Roger. That guy was incredible. But he did not take other people's content and he did not attack others, but he posted reviews critical of movies, both positive and negative, for decades. And he was incredibly famous for it. Okay, let's start off with the main issue I have with many reaction creators is their use of others' work without permission, right? So, as an author, I've had my share of criticism, which I just said and talked about. But IP misuse is another matter. Okay. First, fair use. It's not pre-approved, okay? So that doesn't, just because you take some content and you post it, doesn't mean it's approved. It doesn't even mean it's authorized. It's a legal defense in U.S. courts that may allow limited use of copyrighted material if a judge agrees. Basically, if you go to court and you claim fair use, you use it as your defense. What I've noticed a lot of times is some will say, oh, this person won fair use. Every case is unique. Every case, you know? So every case is unique. Just because somebody was successful in defending themselves with fair use doesn't mean all uses of fair use are legal. It's a legal defense in U.S. courts that may allow limited use of copyrighted material if a judge agrees. Everyone does it is not a defense. Remember Napster? Everybody thought it was okay because everybody was doing it. So, and simply pausing to add commentary or flipping, cropping doesn't automatically make a work transformative or educational. And in there I say, see U.S. Copyright Office, fair use. Now I did talk to somebody and it's kind of laughable in that person's opinion. I won't give names away, but flipping and cropping is a well-known way to avoid copyright detection on platforms. So what they do in that sense is they flip it, they crop it, they speed it up, and they're trying to avoid copyright detection or copyright ID. And that's recognized, pretty well known in legal sense, and even platforms know it. So if you're reporting, you need to explain clearly what has happened to your video. A lot of people fail to explain themselves clearly about what it is. Okay, so what sets many paranormal reaction creators apart is that they often call paranormal content creators fakers, liars, or scammers. Any kind of public accusation is legally risky. We all know that, right? We inherently know that. But these specific terms are recognized in defamation law as carrying especially high risk because their potential for serious reputational harm. I mean, come on now. Anybody who doesn't think those terms are risky, you might want to talk to a lawyer about that. Those terms in of themselves. Really? So that really can hurt somebody's reputation. It's not fun and games. But anyways, we'll get more to that in a minute. Courts, including the U.S. Supreme Court, have ruled that publicly calling someone a liar or similar merely for disbelieving them, even just as an opinion, can be actionable as defamation. There is no public duty exception for private individuals who make public accusations. So, on the contrary, projecting false authority through a self appointed role that has no official capacity could affect liability. Unlike hearsay cases, reaction videos provide replayable evidence. That's why it's important to save. I'll get to that in a minute. Because unlike hearsay cases, reaction videos provide replayable evidence. That's why it's important to save. I'll get to that in a minute. Because it's replayable, so nobody has to question, well, did that really happen? Because in most defamation cases, it's a lot of he said, she said. But in this sense, when you're dealing with reaction videos, it's pretty cut and dry. This is what he said. This is what it was about. And go from there. And labels like parody don't provide immunity either, especially when statements imply fact. One of the most underestimated legal risks is using someone's likeness. Now, this is a big one, and all creators underestimate this one. Name, image, voice, or other personal information in reaction videos, or any videos for that matter, without consent, even in thumbnails. In the U.S., likeness is protected under privacy and publicity laws, which fair use does not cover. Fair use is for copyrighted material. It is not for privacy and publicity and other laws. It is not a defense for those. So, publicly accessible online does not mean it's free to use or in the public domain. This is a big mistake, and it doesn't matter how many people are doing it. If you find something online and you repost it in your video, well, either you have authorization or you don't. And if you don't have authorization and it's somebody's image of themselves, their likeness in some way, that's why smart creators use licensed content or obtain signed releases. Even famous people are not fair game. Some of the largest statutory damages awards have gone to them. Did you know likeness can even be implied? In White versus Samsung, White won $400,000 because a robot evoked her identity. That's it. In Waits versus Frito-Lay, Waits won $2.5 million for its use of a sound-alike voice. So that wasn't even direct, that was implying. So legal media of people is typically licensed from sites like Getty, other agency, or directly from the individuals. That's the best, especially when you're doing paranormal content, right to the person, say, hey, can I use this piece of content? This is what I want to do with it. U.S. fair use offers no protection for defamation, privacy, publicity, harassment, or other non-copyright claims. This is why IP holders often bring multiple claims in a lawsuit. So, in the UK or EU, likeness is protected under privacy and data protection laws. There is a difference. In the States, you have publicity. In your EU and UK, you have data protection laws. Especially, and this is really important for outside the United States, especially in Europe and the UK, is misleading, harmful, or commercial use. Commercial use means monetizing the video. So if they're doing that with your likeness, talk to a lawyer. If you're publishing online and you're not willing to discuss with the lawyer or to go to get legal advice, then it's hard to complain about something if you're not going to get the legal advice you need from an authorized source such as an attorney. So that is something people really need to decide when they're publishing online, if they're willing to get legal advice. I've been to court several times, and it has always been worth it. I do have legal insurance. Most people I advise get legal insurance. So here we go. Privacy complaints are often filed with platforms first, and lawsuits can follow. Most platforms will allow you to make a claim with them first. And then if you still want to go to court, that's up to you. Talk to your lawyer. This all matters because original creators invest significant time, energy, and resources into their work. When that work is misused, it can harm reputation, damage partnerships, impact sponsorships, and even affect employment opportunities. That's all true. I mean, come on. That's common sense right there. Need I say more? Creators are not just making videos, they're building brands. Unauthorized use can devalue or interfere with licensing opportunities. I experienced this when one of my IPs was blocked due to unauthorized use, and that unfortunately was no fun. The thing is, criticism does not require unauthorized use. Thousands legally post critical reviews daily. Not all reaction videos are malicious. If you genuinely believe your rights were violated or no copyright exception applies, and you want it removed, consider these things. It's a legal process, so avoid responding with anger, insults, or public retaliation. Public retaliation can only help them. Send a polite takedown request to the reactor. Refusing to remove infringing content after being notified may contribute to a finding of willful infringement, which can increase potential statutory damages. So here's the thing. Once you send a takedown request to potential infringer, once you send them a notice and you've informed them, they can no longer say they're ignorant of that they're using material without permission and that they should have asked for permission or anything like that. They can't pretend like they don't know. Document everything. Well, that should go without saying. Save everything. The videos, URLs, thumbnails, and any use of fake or liar, scammer, or any other words of that nature. And save follow-up. Follow-ups are really important. Save everything they post about you, whether they mention your name or not, as that might show willful intent. So screenshot comments, they can be valuable evidence of reputational and market harm. So report infringement to platforms for removal. Under safe harbor provisions, platforms must remove infringing content after receiving a valid takedown notice to maintain their immunity. Safe harbor protection applies only to the platforms, we just talked about that a little while ago, not to the person who uploaded the content. If you receive an automated fair use reply from YouTube, you may need to email the full explanation to copyright@youtube.com. And that's the thing, is a lot of times you don't have a lot of space to put in there in the report everything that's important. And a lot of times the reaction creator will write to YouTube and say, hey, it was fair use, right? And so you need to respond to that and clarify how it's not fair use. We'll go further into that, but it's very important that you give a detailed explanation so that YouTube knows that you understand your rights. But before you do that, know your rights. That's my next line. The more detailed, informed your request is, the more likely it will be honored. And that goes with most anything. But this is something everybody should know if you're creating content on YouTube videos. Fair use is evaluated in court using 4 key factors. A best practice approach in removal requests to platform is to explain how these factors apply to your case. Here are examples how they may affect paranormal content. I put para content for short. 1, purpose and character of use. Many para reaction creators focus on discrediting, but in a legal context, discrediting is not the same as criticizing. A lot of people misunderstand that. Calling someone or implying that they are a liar, faker, or scammer goes beyond mere commentary on a copyrighted work and becomes a personal attack on the creator's credibility and identity. Remember, fair use is about commentary on a copyrighted work. So you can comment on it. It is not about attacking the creator. It is not about discrediting the creator. And remember, the creator himself or herself is not a copyrighted work. They are an individual, a person, a human being. Only the work itself is copyrighted. So the commentary must be about the video content, not the creator. Once it steps across that line from commentary on the copyrighted work and it becomes about the creator, it's no longer anything to do with fair use. A lawyer. Okay, so anyways, such attacks on the creator, directly or indirectly, are generally not protected by fair use and may undermine and nullify a fair use defense. Talk to a lawyer so you can get clarity on that. Thumbnails stamped with fake and other terms like that pretty much give away the intent. Anyway, let's go to, so number 2, nature of the original work. Videos capturing alleged paranormal events often involve rare, spontaneous moments in distinctive settings recorded in creative and original ways. This type of content may be less likely to qualify for fair use, especially when key moments, the heart of the work, are reused. We're going to get into that. So, and now the next is amount of substantiality used. Okay, para-reaction videos often take the key scenes involving alleged paranormal activity. So I think it's pretty obvious, and most people know, that any paranormal reaction content creator is going to take the most compelling paranormal activity and use it for their reaction to, discredit it, or whatever they're going to do with it to call it out as fake or lying or scamming or whatever it is they're doing at that particular. Not all paranormal reaction creators do that, but the majority do. So the fact of the matter is, even the briefest use of these key moments weighs against the fair use defense, as they are the heart of the video and are highly protected under copyright law. In the landmark fair use case Harper and Row versus Nation, the U.S. Supreme Court ruled that copying even a small portion can be infringing if it includes the most valuable parts, the heart of the work. So that established an important legal standard for fair use. Okay, so alleged paranormal activity often forms the heart of videos involving paranormal content because it is the holy grail of this type of content. And I don't think anybody debates that. I mean, have you captured paranormal activity on your video, then yeah, that's the heart of your work, most likely. You determine that, not me. So you, as the creator of your video, you determine what the heart of the work is. Reaction creators have no legal authority to decide what the heart of someone else's work is, and that's true. No one else outside a courtroom has any decision making as far as the heart of your work is, and neither do I. I can't decide what the heart of your work is or so on just by watching it. I can have an idea, but I don't have any legal authority to determine what the heart of your work is. If you say that's the heart of your work, then the platform needs to go with that because that's your work. So, and platforms can't know the heart unless informed by the original creator. It's not debatable unless you go to court and then somebody tries to argue, hey, that's not the heart of the work. Then the court has to determine whether it is or not. There is the number 4 is the effect on the market. So if it has a negative effect on the market, that weighs against a fair use defense. So that's really, really important. So use that harms viewership, damages reputation, or poisons audience perception is considered market harm. And viewer comments and sudden spikes in dislike can be key evidence for that. I mean, that is the direct influence that happens. So the next part is, in my opinion, also important. Fair use is a legal defense only under U.S. law, in U.S. jurisdiction. It's best practice to state locations in removal requests to platforms, whether the original content was uploaded outside the US or if the reaction creator is based outside the US. Platforms consider jurisdiction when clearly stated. Otherwise, they often default to US law. And as we said earlier, they can verify the locations. I mean, platforms know where you're uploading from, they can see that. If legal action is pursued in the reaction creator's country, for example in the UK, stricter copyright laws apply. The fair dealing provision under UK copyright law offers less protection. To date, I have not found any UK court that has upheld fair dealing as a defense for reaction style use. And TikStack Ltd versus BT, the High Court rejected a fair dealing claim for just 8 seconds of footage, showing how narrow the UK standard is. That was only 8 seconds, showing you how even 8 seconds didn't qualify. In the UK, fair dealing is intended to cover critique of the work, not attacks on the creator. Basically what I just talked a moment ago about fair use, how it's critique of the work. So, across Europe, the InfoSoc directive imposes strict limits, and various countries have their own data and privacy and so on protection laws. YouTube is a global platform, so rights holders with standing may file suit in the infringer's country if they choose. When it comes to that, again, I can't stress enough, talk to a lawyer, because YouTube is global. In other words, your content is showed around the world. And that will give you different rights, in other words, to be able to file in other countries. Just because content isn't removed doesn't mean it's legal. Right. Not all platforms get it right. Platforms are not courts. So just because it hasn't been taken down doesn't mean it's legal. But it's important to understand that platforms rely on IP holders for what happened. So be confident, clear, and factual in your reporting. It's not enough to click the report button and type copyright infringement. You have to do more than that. Explain how was the work used. Why wasn't it fair use? Does it contain the heart? What's the jurisdiction? Does it contain your likeness? The more specific you are, the better. Also, I'd be cautious about taking legal advice from anyone whose unauthorized use might be in dispute. Okay, so that's I think that goes without saying. If you're against somebody doing something against you, then why would you take their legal advice? So I know how upsetting, and I know how upsetting it is to see your content or likeness misused. But you're not legally powerless. You're not. From what I've seen, many disputes fail because the original creator didn't understand the laws involved or how to report infringement or privacy issues properly, and or how to respond effectively to rebuttals. As someone who instructs up-and-coming authors, I always stress the importance of learning your rights. Really, if you're going to publish in public, that's what publishing is, you owe it to yourself to know your rights, your legal rights. And there are going to be people, and paranormal reaction creators are not harmless, but there's worse out there than that. Much worse. Trust me. I've been involved in things that you would not believe that others would do with your intellectual property. Paranormal reaction creators, with some of the things they say, they can really hurt your reputation. They can affect you in the outside world. They don't seem to care how much they're hurting someone else in the guise of getting the truth out there. And it can be really, really destructive. You know, people spend a lot of money to go to locations, and they spend a lot of time and effort and care. And that's all value. It's not harmless, but there's a lot worse out there is what I'm trying to say. So again, don't just take my word for any of this. Do not, please, consult a qualified attorney. Whatever you do, please consult a qualified attorney. You owe it to yourself. That's my monitors coming back up. Statutes of limitations for copyright are usually up to 3 years. Mostly that's in the United States. And in some cases, like for example in the UK, it's up to 6 years in certain situations. Defamation is usually a shorter time period. So again, talk to a lawyer. Find out what the statute of limitations for your situation is, if that's the route you want to go, and so on. So that's pretty much it. And I'm not going to mention a lot more outside this article, and I don't want to give too much of my opinion outside of it without it being first reviewed by a legal source. I am being very clear to you that these are my opinions and interpretations, of course. Like I said earlier, I tried to check everything before I posted it to make sure it was accurate. If you find anything that wasn't accurate, please let me know. Feel free to email me. My email is on my About page. But I will tell you this, I will not correct anything if it does not come with a legal source. You say, okay, Brian, you said this was wrong. Here is the correction, and you can find it here. That to me, for a creator to go online and say, oh, I don't believe this, and that's wrong, that can't be, and safe harbor, fair use, and just throwing terms out, which a lot of people do, that's not helpful. I want to actually see the legal analysis for whatever you're telling me, so that I can say, okay, you're right, and then I will make a correction. I think that's fair. So my personal opinion about paranormal reaction creators, this is my thing, really, is ask first. Keeps yourself out of so much trouble. I don't care if you already have 1 million followers or 2 million. That doesn't mean it's okay. So ask first. Be honest of what you want to use it for and what you're going to say in it. And creators, make sure you get that in writing, not verbally, in writing, unless you have video chat that's recorded, so that you can show later that that's not what was agreed upon. As far as likeness and whatnot, I suggest you talk to lawyers about that, because I see a lot of paranormal reaction channels and other channels using people's likeness, not just for reacting, but in other ways that have and can get people in a lot of trouble. That right there is more expensive than a copyright infringement. You can actually be sued for a ton more than for copyright infringement, believe it or not. And sky's the limit on that. So just be careful, especially if you're commercializing or monetizing somebody else's image or likeness. That can really get you. And that's really underestimated. I'm surprised how underestimated that. I've read a couple stories of people who got sued. Really? How did you not know that? So just be careful. Don't take my word for it. Talk to a lawyer. I say that every single time. All right, so I hope this video was helpful. I don't do a lot of videos like this, and I probably won't do any more because that's not what my channel's for. So that's it. Hope you enjoyed this video. See ya. Did you say something to me, David? No. What is that? Oh my God. It's a rabbit. Holy shit. But what's it running from? Oh, paramo. Okay. Yeah, because to run at us like that, it had to be scared.